Good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series as we're looking at lawyer and paralegal bencher candidates. As always, the views and opinions are of the candidates alone. They don't reflect me, Justice and Pieces, Trials College, or any other education institution or organization that I'm affiliated with. Continuing on this evening, we have Gerald joining us here today. So thanks so much, Gerald, for speaking with us. Perhaps you could tell us a little bit more about yourself.
Sure. Then thank you, JP, for having me and giving me this opportunity. I practice litigation, predominantly criminal and regulatory litigation, at a firm called Stockwoods in Toronto. We're about 20 plus lawyers. I grew up practicing mainly criminal defense and constitutional law with Clayton Ruby at a firm which was then known as Ruby Edward, and then Ruby Schiller, and later Ruby Schiller Chan Hassan. So I spent a large part of my career early on doing mainly criminal defense work, and I still do mainly criminal defense work at Stockwoods, but I've sort of broadened the practice a little bit more. And in addition to my practice, I've always tried to carve out a significant chunk of my time to, engage in what I would consider to be public service within the legal profession and beyond. And so I currently serve as a member on the Judicial Appointments Advisory Committee for the Ontario Court of Justice. I had previously spent a lot of my time being involved with the Federation of Asian Canadian Lawyers, serving on its board, serving on its advocacy and policy committee, and then later as president. And so that's sort of where I have been spending most of my time in recent years when it comes to legal practice and sort of my extra practice commitments.
Now, and speaking of extra practice commitments, right, the new one that you're hoping to take on is becoming a bencher, and sort of why are you running for bencher, and sort of how did this come about?
Sure. I'd been hearing about the Law Society and the role of benchers in convocation sort of long before I thought about running. And that was mainly through my relationship with Clay. Clay Ruby was I think the longest serving bencher in convocation's history. This was before they brought in term limits. But I just remember Clay coming back from convocation to the office, and we would go for lunch. We would talk about our cases, and he would talk about what was going on at the Law Society and how meaningful it was for him to serve in convocation, where he could take meaningful steps to advance access to justice and ensure that the profession was serving the public properly and enhancing the fairness of the disciplinary process, for example. So I would hear all these stories, and that among many other things that Clay did inspired me. And then when I got involved with the Federation of Asian Canadian Lawyers, it was in my capacity as a board member and then president that I started tracking the goings on at the Law Society more closely, particularly during the whole debate about the challenges faced by racialized licensees and the equity, diversity, and inclusion initiatives that flowed from that. But not just that, also other things that it was doing, when it came to, thinking through articling and how it is that we're licensing legal professionals, as well as what it was doing on the access to justice front and ensuring sustainable funding for legal aid. I took a real interest in those issues in my role as a FACL board member and president. And so that got me thinking more specifically and concretely about, should maybe this is a capacity in which I could try to serve the public after I stepped down from FACL. And so that happened last year, and that's when the opportunity arose to think more seriously about the 2023 bencher elections. I've lost all track of time after COVID. But that's sort of the path that led me to the decision to run for bencher. And then certainly when I found out that there would be the Good Governance Coalition trying to organize an effort to restore thoughtful governance and responsible governance to the Law Society after the last 4 years, it was a hard opportunity to resist in terms of finding the most effective way for me to serve the profession and serve the public, which is what I've always tried to devote a significant amount of my time to do.
Yeah, and I think certainly, that brings about the question that I've been posing to some of your colleagues that are running as part of the coalition is that on one hand, they're pointing to the Stop SOP group as it was in 2019, kind of taking control of the law society, so to speak, or of the elections, and having all of them get elected. And then there's a problem with that. But then on the other hand, there's 45 of you running as the Good Governance Coalition, 40 lawyers,
Mm-hmm.
5 paralegals. But that's okay. But the other one is not. And then if we are elected, then maybe we'll look at doing away with slates altogether, which kind of it's kind of like a cyclical argument, right? That how can you
Yeah.
say this and then do this? So is there a way you can kind of reconcile those two sort of perspectives?
Sure. And I fully acknowledge that, it seems like a bit of a circuitous or winding path to get to the place that we've gotten to. I guess what I would say is I see this very much as a practical necessity. I was following the Law Society debates and election pretty closely at the time in 2019. And I recall the Stop Stop slate being able to mobilize its supporters around opposition to a single issue, namely the statement of principles, which, by the way, was done away with soon after the 2019 election, and nobody has sought to revive since, and nobody is seeking to revive it. But what troubled me after that was, even after that issue was taken off the table, you now had a block of 22 lawyers in convocation who, on many other issues, were in large part voting as a block. And that just, in my view, is incompatible with the role of benchers as basically members of the board of the Law Society governing the legal profession in the public interest. Every bencher owes a fiduciary duty to the Law Society to serve in the public interest and ought to bring sort of their independent judgment to bear on specific issues as they come up. And politics really should be taken out of that equation. And that's not what I've been seeing in the last 4 years with the Stop Stop, now rebranded Full Stop slate. And so that's been concerning to me. And what sort of brought that about in 2019 was, not just opposition to a single issue, but also among other candidates, vote splitting. And so I think very much as a matter of practical necessity, I think it is important, and I thought it was important to run not just as a candidate independently, but as a part of a good governance coalition, provided that, not that I agreed with the views of every other candidate in the coalition, because I don't, and I don't frankly know what the views of many of the candidates in the coalition are on a range of issues, nor should I agree with them on a range of issues. But I thought it was important to run as part of the coalition because of the dangers of what might happen otherwise, practically speaking, where you could have another round of vote splitting and the sort of the continuation of this slate at the Law Society, voting as a block on issues, not just voting as a block on issues, but also being fairly hostile, and I think I'm being fair in saying this, fairly hostile to this notion of equity and inclusion being a good thing, far beyond just the statement of principles, which is a dead issue. And so those are the practical reasons why I thought it important in this pivotal election to run as part of a coalition to address the concerns of vote splitting, to prevent that from happening again. I think everybody in the coalition agrees, and I think it's on the website, that if we are elected, that one of the things we are going to look into is electoral reform to prevent the sort of continuation of slates and block voting, because I think all of us agree, certainly I take the view that it's incompatible with the role of a bencher. And that's also the reason why the coalition is very clear that while we're running as a collective, we don't purport to agree on or take similar positions on all the issues. In fact, I think if you even if you look at just the one issue, the statement of principles, you'll find people who are on both sides of that issue back when things were litigated, for lack of a better word, in 2019 for those who were either incumbents or taking a position at the time. So there's a range of perspectives being represented and reflected in the coalition, and I think that's where you're going to get the best governance. I know we sort of called ourselves a good governance coalition, but to my mind, what that means is there is a respect for the process. There is a respect for sort of healthy, civil, respectful debate and thoughtful debate on the issues. There are a diversity of perspectives being brought to bear on the issues, and diversity in every sense, right? Not just racial diversity or gender diversity, but in many respects, professional diversity when it comes to our professional backgrounds, small firms, big firms, legal clinics, um, barristers, solicitors, government, etc. I think that's where you're going to get the best decision making in the interest of the public, and that's what I think the coalition offers. And so that's why I've chosen to run as a member of the coalition, and have been urging people who may be supportive of my campaign or my candidacy to consider not just voting for me, but to vote for all members of the coalition in this one pivotal election, just so that we can uh, uh, address the vote splitting that happened in 2019 and then move forward from here. Hopefully, this will be the last election where you have two competing slates of this sort. But I do see it as a practical necessity this one time.
Now you've touched on sort of I guess the diversity of thought and diversity generally.
Mm-hmm.
Perhaps maybe you can tell us a little bit more about some of the things that if you are elected bencher, that you'd like to see discussed and kind of brought to the bencher or convocation in terms of issues that may not have been to the forefront maybe in the last 4 years.
Sure. I think there's so many challenges that we as a profession are going to face in the next 4 years and beyond that, that require thoughtful, serious governance, and they have nothing to do, by the way, with stopping woke, which I know is a sort of mantra of the full stop slate. That's not what I think of when I think about the challenges facing the profession going forward. What I do think about a lot are, access to justice. That's a central part of the Law Society statutory mandate, and that continues to be something that we're struggling with in terms of the rising cost of legal services. In this, not just in the civil and criminal world. I mean, I'm more familiar with criminal justice because that's where I practice, and legal aid continues to be underfunded. I think FOLA recently called for an increase in funding for legal aid by over 100 million annually, and that would simply restore it to its 2014 levels. And that just underscores how severely it has been underfunded, and that has longer term consequences and costs for the administration of justice, because you'll have unfair trials leading to retrials, you'll have wrongful convictions that will require case reviews, etc. And so that, I think, is a central challenge. And the Law Society doesn't fund legal aid, but it does play an important advocacy role as a leader in the Alliance for Sustainable Legal Aid in organizing others to advocate for an increase in legal aid funding. So that's one issue. I think law libraries is a critical issue that relates both to access to justice and to professional competence, because smalls and souls, particularly outside of large urban centers like Toronto, rely heavily on their local law library to access the latest legal information and to adequately serve their clients. And so I think the Law Society plays an important role in ensuring that we have a sustainable means of funding law libraries and not offloading that responsibility to others. So that's another critical issue in my view. Access to justice and professional competence in terms of how those relate to technology, emerging technologies, I think is something that we have to stay on top of and get ahead of. I've taken a great interest in sort of the intersection between law and technology in a lot of my legal writing. I've written and co-edited books on digital evidence, digital privacy, artificial intelligence, because I've always been interested and curious about those issues. But we are seeing sort of these technologies race ahead, and every industry and every regulator and every organization is going to have to get ahead of this. And the Law Society, as the regulator of legal service providers in Ontario, is no exception. And I think it's going to present both challenges when it comes to how do you ensure reliability and standards of competence are being met and biases are not creeping into these tools on the one hand, but it's also going to create a lot of opportunities on the other hand, I think, for access to justice. And so I think the Law Society has to carefully consider both in sort of examining that issue. And so that's another issue I would highlight. And then there are other, I don't want to use up all the interview time, but, there are other issues as well. I mean, I think COVID has brought about a real mentorship deficit or exacerbated the existing mentorship deficit that many licensees were already experiencing. And I think that that's another important issue when we talk about professional competence, especially among our younger members, that we need to think about and examine closely.
Right now, and in terms of all of these ideas here and things that the Law Society is already doing, no, you mentioned certainly part of the mantra there, stop woke, but then there's also the stop bloat and stop creep, kind of referring to, well, how much is all of this, essentially going to cost, whether it's the libraries, whether it's some of these EDI initiatives that they point to, or even mentorship and for newly called licensees. I know part of the difficulty might be just the amount of the fees that they're paying, right? In terms of how all of this can be done.
Yeah.
But at the same time, we need to have, compensation funds that are properly, replenished and so forth. So, I mean, what exactly, I guess, is the role of the Law Society in kind of all of these issues, and how much of it can be sort of, other organizations sort of take the lead, whether for example, the Criminal Lawyers Association could advocate
Yeah.
for legal aid. FACL could advocate for more diversity initiatives and mentorship, right? I mean, these organizations are doing these types of things. So is that kind of something that needs to be folded into the Law Society, or can it be dealt with, even the law libraries in terms of, other avenues to kind of have that revenue or money or support for these things rather than coming from the Law Society itself?
Sure. So I guess what I'd say is I don't think it's an either or. And I would start with what is the Law Society's central mandate as set out in the statute. I agree the Law Society needs to focus on what its mandate is in the statute, right? But if we look at the Law Society Act, access to justice is in there. Ensuring professional competence for sure is what the Law Society has to be driven to do. And so that, I think, is the starting point. From there, I think absolutely benchers have a responsibility to ensure that we are meeting our statutory mandate in the most financially responsible and prudent and transparent manner. I mean, there's no question about that. And I think that has to be a huge priority for benchers as they are scrutinizing the budget that gets put forward at convocation, as they're thinking through how much funding is actually being allocated to these different initiatives, because as you noted, I mean, that the cost is borne by licensees. And so I think we've got to be careful with money in that fashion. At the same time, though, I think we have to, it's not always an answer to simply opt for the lowest cost option in the short term, because I think that often has longer term cost consequences for the profession and for the public we serve, right? And so if you think about, for example, cutting funding to law libraries and shifting that funding to another body like a law foundation, while that may appear attractive in the short term because the Law Society has to spend less money, if you are removing a critical resource for smalls and souls outside of Toronto in terms of their ability to access legal information, because organizations like the Law Foundation don't have consistent cash flows. It's not a sustainable source of funding for something like law libraries. If you're removing this as an option for smalls and souls, what you're going to have are, first of all, smalls and souls, if they want to keep up with access to legal information, may have to pay for the service themselves at a higher cost individually. If they don't have access to the latest sort of legal resources, that may impact their practice and that may bring down the standards of competence. That's going to affect the public. That is going to increase longer term costs of the Law Society, because it's then going to have to do more regulation of competence on the back end through discipline, which is very costly and not an effective way of promoting competence. So I just cite that as one example to make the point that absolutely we have to be mindful of cost, but I think we have to be mindful of cost in the global sense, not just short-term solutions that may be appealing superficially, but to think seriously about what are the longer-term cost consequences and what are the consequences for the issues that are a central part of our mandate as assigned to the Law Society by statute: access to justice and professional competence. Because at the end of the day, we talk about good governance in our coalition. I know the Full Stop slate, talks about big governance. At the end of the day, what we need is good governance in the sense of a commitment to a good process, and that leads to smart governance in terms of smart decisions being made that serve the public and serve our statutory mandate in a financially responsible way. And that's what's going to enhance the public's confidence in us, which is where I think we have to end up, because someone's going to govern lawyers and paralegals. We've had the privilege of self-regulation, and that has been critical, I think, to our role and our democracy and the independence of the bar. But I don't think we should take self-regulation for granted, because in other jurisdictions around the world where the government doesn't think that lawyers and paralegals are doing a good enough job regulating themselves, they have stepped in and regulated lawyers and paralegals for them. And I don't think that's a model of regulation that any of us want, because of the critical importance of the independence of the bar. And so I think that reinforces our responsibility to take our statutory mandate seriously, and to bring thoughtful, smart solutions to our problems that reduce costs, not just in the short term, but in the long term, and not just sort of, yes, financial costs to licensees, but also financial costs to the administration of justice and to the broader public.
You brought up professional competence, and that being, a mandated role there from the Law Society. And I did get a chance to speak to a member from the Full Stop group, again, pointing to those same things about professional competence and the importance of taking care of that. So as you point out, it doesn't go into discipline, which costs a lot more money. But no, in terms of professional competence, and again, appreciate the fact, your experience in criminal defense. Even in you have Gladue, and you have even bail factors, right, that involve looking at sort of cultural competence, right, in terms of trauma-informed lawyering and concepts related to that is that, again, part of the Law Society's role there in terms of making sure, in terms of professional competence, it includes more than just make sure you reconcile your trust account, before the 25th of the month and stuff like that. I mean, what else should be included there from the Law Society's perspective in terms of ensuring its licensees are professionally competent?
No, I think that's a great question. And I think social context does matter, right, to professional competence. We are serving our clients, not in a vacuum, in terms of what's going on around them, what has brought them to our office. They've lived a whole life before they ever came into our office with a legal problem. And not everybody has experienced the burden of racial discrimination, just to take one example, equally, to that point where they come into your office with a legal problem. And I think we have to be aware of the social context in which our clients live their lives and their lived experiences, if we are to adequately serve them and to competently serve them. And that's, the Supreme Court of Canada has said that in the Trinity Western Law Society of British Columbia case, where the majority said that a diverse bar is a more competent bar. And so I don't, when we talk about equity, diversity, inclusion, I don't think that is can be talked about in isolation from professional competence. Right, the sort of two kind of inform one another, and that's I do bring sort of my perspective as a criminal lawyer to bear on this, because when I think about developments in the jurisprudence that criminal lawyers have pushed forward, I think about Gladue, I think about more recently cases like Morris and Lee, and Sharma, where criminal defense lawyers have demonstrated through their advocacy that we understand that our clients, that their lived reality matters and has to be taken into account by all players in the justice system in order to arrive at a just outcome. And I don't think that professional regulation in the Law Society is any different from that. I think we do have to think about sort of the lives that our clients have led up to this point, and what the implications for them are, and that relates to how we as licensees conduct ourselves and the issues that we have to be aware of.
Gerald, I have students listening in, and while they're not going to be voting in this election, it's certainly important to kind of know the people that and the structure within the Law Society. So I was wondering if you have any words of wisdom. Being a former student that even if I remember was
Right.
talking with before, very useful for me all those years ago. But any words of wisdom for the students that are listening?
Um, I get asked this a lot, and there's a my answer changes from time to time, but I would say this: it's a remarkably rewarding profession, and so I think that's what students should know going into it, and that it's helpful to keep your eye on that and have that in mind as you're going through the slog and the grind, especially in your early years of practice, because everybody is, no one knows what they're doing when they first start practicing. We're all learning, and it's a difficult job to learn as you go and to learn as you do. And so it can be challenging, particularly in those early years of practice. But it's hugely rewarding to be able to help clients. In my experience as a criminal lawyer, at often the most difficult point in their life, where the world just seems to be collapsing on them, and to help them through that process, whether or not you ultimately get a win, right? Of course, it feels great to get a verdict of acquittal in my practice, and vindication for a client's reputation, one of the best feelings in the world. But even where I haven't been successful in that sense, it's remarkably rewarding to be able to at least play your role in ensuring that your clients are treated fairly, have received a fair process, whether in the criminal courts or, like I've done work representing lawyers in front of the Law Society Tribunal, in a forum like that, to ensure that they've been heard, that they feel like they've been treated fairly and had their day in court. That is really satisfying. And so it really is, I think, a noble calling, to act as a lawyer, and not just sort of in my practice area, but across the whole range of practice areas, to be able to help a client through their problems. So keep your mind on that and keep your eye on that, even as you're grinding away and finding it difficult, because of the challenges of the nature of the work, because it is part of a larger cause that I think plays an invaluable role in serving the public.
Perfect. So, Gerald, final question here for you. There'll hopefully be some lawyers that are listening, and they'll be wondering, why should I use one of my 40 votes for you, Gerald? So, what would you say to them in response to that?
I'd say that I will be unyieldingly committed to serving the public interest. That I am experienced when it comes to serving the public, in the context of the legal profession, given my various roles with FACL and the CLA and Innocence Canada, etc., and that I will always listen, to the members of the public, to the licensees in our profession who practice in a range of areas in which I don't have any experience in. I think I've got a lot to learn from my colleagues at the bar, and I commit to always doing that, and then bringing a thoughtful and informed approach to the issues and the challenges that we're going to debate at convocation, and to doing so with a lot of enthusiasm and a lot of energy, because I am very excited about the challenges that lie ahead and what our profession can do collectively to solve them, so that we continue to maintain and enhance the reputation of the bar when it comes to the public.
Perfect. So, once again, thanks for taking the time and joining us, and thanks for everyone for tuning in. Take care.
Thanks, JP. Thank you all.